Please be seated. Morning, Council. Let me call your case. This is case CV15 500. Aprim et al. Versus the City of Phoenix, and this is the time set for oral argument. Council, you both have 20 minutes to present your arguments. Mr. Abney, you can set aside some time for rebuttal. Just let us know. We've reviewed everything. We've looked at the case. We've read the brief, so we're very familiar with the issues. I would just note that the proceedings today will be uploaded to our court website, and the public can view that. I want you to be aware of that before you make your arguments today. Mr. Abney, your argument.
Thank you. May it please the court. My name is David Abney. I'm here representing the plaintiff's appellants. Thank you for the opportunity to talk about the case. The trial lawyer filed his complaint and then an amended complaint against the city, and a short time after that got a motion to dismiss. The motion to dismiss had the notice of claim attached to it. He looked at that. He looked at the rule and came to the conclusion that it was automatically converted into a motion for summary judgment, so he calendared it that way. Then, before the time had elapsed for responding as if it were a motion for summary judgment, the trial court entered an order dismissing the case. The trial lawyer was dismayed, to put it mildly, and filed a whole bunch of stuff all at once: a response to the motion to dismiss, a motion to reconsider, a motion for more time, and a request for the court to treat the motion to dismiss as a motion for summary judgment. The trial court denied all of those things. He advised him to file a Rule 60C motion, which he filed, and the court denied that, denied all the other motions, and that was the end of that.
Was that really the end of that, though? I'm sympathetic to the notion that trial courts shouldn't just grant motions because a response is a few days late, but in this case, it seems that the trial court ultimately considered all of the arguments that plaintiff had on the merits and rejected them, which is a better practice.
Yes. Well, it's interesting because I've got two streams here to deal with, and it all comes back into one river, of course, in the end. But the one stream is whether the discovery rule applies, the statutory discovery rule for notices of claim. I submit that it does. There was no indication right after the accident other than the typical my light's green, no, my light's green sort of thing that you get over and over and over, which is not really a red flag of any kind, pardon the color there. And plus, the accident report itself said, while at this, investigating this, we saw no evidence of any malfunctioning light. That's what the police said. But the photos that they took during the investigation, the 267 photos, 3 of them, oddly enough, showed, and you may have seen them I put the color versions up for the court to look at. 3 of them show red light, green light on the same light thing being illuminated at the same time, which is an impossibility the way these lights are done. So something was going on with the lights. Now, maybe it was a post-collision sort of malfunction.
Do you know when those photos were taken?
The night of the collision, shortly afterwards.
Okay.
And you can still see the vehicles there, and the police officers wandering around doing their things. So it was that night, shortly after the collision. Now, it may be, ultimately, this city will say and can establish, well, this is just something that happened after the collision, maybe recycled the lights, checked them, test, who knows? But maybe it was that way before the collision.
Did the photographs indicate the shutter speed that was used?
No, it didn't, and I thought about that, but I saw no blurring whatsoever in anything associated with the photos, and there were people around. So I was thinking maybe it did show the cycle, but I didn't see any indication of that, Your Honor. And that is something certainly that the city can investigate if we ever get to the merits of this by saying, well, there's nothing wrong with our lights. What you're looking at here is an optical illusion triggered by an overexposure or long exposure, 1 second, 2 second, 5 second exposure, whatever it might be. But, it gets down to this. As a plaintiff's lawyer, you don't usually order the accident photos. They're expensive, especially 267 of them. And I'm surprised that he actually subpoenaed them, although...
Why would they be expensive? It's a public records request for a non-commercial purpose.
They charge you. Cities, counties, state, they charge you for different things. And then you get into a fight about that.
Okay, that's a case for another day.
It is indeed. Sometimes they charge you, sometimes they don't, and when they do charge you, it's right up through the roof. A subpoena is an interesting thing, though, to get records because there's certain limits as to how much they can charge you, and you usually have better luck with a subpoena. And I don't know why the timing of getting the records, the photos. I was just shocked. I mean, I'm colorblind, and I really had to look at these 3 pictures when he showed them to me. He said, "Oh, I see what you mean. There's 2 lights here. One's up top, one's down below. Okay, I get it." Although I can see shades, and I saw that there was something going on there. But I'm really surprised that going through 267 photos, somebody would actually notice that discrepancy, and then think, well, maybe there's a claim here, and file the notice of claim. It may or may not be the strongest case on the planet. I don't know, but at least it's a case that should be litigated. I believe that the court should have recognized that this was a reasonable discovery. And allow that to go forward on that stream of the case.
Is part of your argument that this type of defect, if in fact it exists, is not one that you would expect with an accident and intersection, that the lights would be green at the same time?
Oh, I've never seen it, and I've talked with other lawyers about this. They've never run into it. I'm sure it must happen. There must be cases where traffic lights go on the fritz.
Well, when Judge Swan comes to court, all the lights turn green all the way through town so he can get here on time.
Well, that's a spiritual blessing. That's a different thing. But and of course, if you've got a fire engine with these little strobe lights they use, they will actually turn the lights green for them. But it's red the other way, and then it goes green. You notice an odd strobe. There's a sensor on many of the intersections, and it will change the light for them. But there's no evidence of anything like that here. I submit to you, the argument is fairly straightforward. If you look at this rule, it has shall 2 times. There shall be treated as a motion for summary judgment, shall be given a reasonable opportunity. And of course, as you know, from years on the court and from practice as litigators, shall is a very, very slippery word. It could mean future. I shall go to the store. Or once A happens, B shall do something. That's just simple future. Or it can mean may, or it can mean must.
Mr. Abney, what does it matter if she ruled on a motion for summary judgment or a motion to dismiss? She considered your client's response. She asked the city to file a reply. She asked the city to file a response to the motion to reconsider. Seems to me she considered everything and still came up with her decision. So does it really matter whether it was a motion for summary judgment or a motion to dismiss?
I hope it doesn't matter. I hope that on the merits, the court would agree that there was the discovery rule should apply, which is really the merits, I suppose, of what's going on here, to get the case before somebody who will actually look at whether there's a malfunction or not, whether that's resolved at a summary judgment or whether that goes to trial.
That it's a question of first impression under the notice of claim statute whether there's any discovery component, are you?
There is a discovery rule.
That's what I mean. I mean, you're not suggesting that we issue a landmark decision in this case announcing for the first time that the discovery rule applies. When you say the discovery rule, okay.
No, not at all. Well, I think the discovery rule just is a matter of the common law approach to litigation and pleadings and practice that Arizona has had as its principle for many, many years would apply. But the legislature specifically enacted a discovery rule for notices of claim. I think we fit comfortably within the discovery rule if we drill down to the merits, which is fine with me. But on the procedural aspect of the case, the rule itself, my final word on that is if you take it at its plain value and treat shall as meaning must, then what he did was okay. There should have been an automatic conversion. And if you approach it as the way Judge Orozco may be approaching it, well, she gave him his chance. She listened to all this stuff and got to the merits. I think we win on that approach as well. I would like to reserve my remaining time unless there's more questions.
No. Thank you, counsel.
Right. Thank you.
Mr. Matherson, your argument?
May it please the court, my name is Clarence Matherson, Jr., Assistant City Attorney for the City of Phoenix, and I represent the appellee, the City of Phoenix, in this matter. And we would ask that this court affirm the trial court's decision in this matter. First, on the motion to dismiss. Second, on the Rule 60C motion and the motion for plaintiff's relief under ARS 12-504. The first thing this court should remember is that the standard of review in this case is abuse of discretion, and just about every decision that the trial court made, the standard of review is abuse of discretion. So therefore, you cannot substitute your judgment for that of the trial courts. So the initial decision that the court made to dismiss the motion, to grant the motion to dismiss when she did not have a response to that motion to dismiss, that review on appeal, again, is abuse of discretion, and that's discussed
Did the trial court even really do that? By the end of the day, the trial court had so many filings and considered them all. Can we really say that this was Rule 7.1 dismissal?
I think we can, Your Honor, and the reason why I say that is the fact that she ultimately considered their other filings, I don't think dismisses her initial judgment in dismissing the complaint. She had the discretion to dismiss the complaint initially without reviewing their responses at all, because she didn't get a response, and that's identified in strategic development. That's discussed under Rule 7.1.
I think they do that more in federal court, where you're 5 minutes late filing your response and your whole case is gone. But that is not a practice that I've ever seen recognized as valid in any of our appellate decisions here.
And I would slightly disagree. If you look at strategic development, which is cited in the briefs, there is a reference to that specific fact. And strategic development is much like this case, where we have motion to dismiss filed, no response filed within that motion to dismiss timeline, and the court grants the motion. And in strategic development, the court states that the trial court had every right, and it would be an abuse of discretion standard to determine whether or not she initially granted that motion to dismiss. Now, I will admit, I will agree with you that the trial court here considered all the other pleadings that the plaintiff filed, but this court can make a decision based on that initial grant.
It's true we can affirm on any grounds, but given the trial court's consideration of the merits, maybe we should move to the merits here.
I'm willing to do that, Your Honor. Discussing the merits of the case, and again, this is all abuse of discretion. The trial court properly found that plaintiff was not entitled to relief under Rule 60C. As the court knows, the standard under Rule 60C is excusable neglect. The plaintiff's counsel in this case cannot fit under that standard. Everything he did in this case was, nothing he did in this case was excusable neglect.
Well, counsel, that is kind of unusual. I mean, I don't know how many times you would think to yourself, well, I think I'm gonna see if the traffic lights are working. As part of a traffic accident where you've got a DUI driver, I'm just that whole issue of wondering whether you should pursue something that's so uncommon. I mean, have you ever heard of traffic lights not working, or the two traffic lights showing red or green at the same time? Or that's kind of an unusual situation. Wouldn't you agree with me?
Well, first of all, I was discussing a different point, but we can discuss your point. I don't know if I've ever seen that, but I can't tell you that I've seen everything. So, you know, the issue in this case is whether or not an attorney, trial attorney, plaintiff's attorney, whoever, has an obligation to do a fair investigation of a case before he files suit. Plaintiff's counsel in their opening brief referenced a treatise regarding the investigation of auto collision accidents, and the first thing it says is that you've got to gather all the evidence, including the accident reports, including photographs. So you have an obligation to conduct a fair investigation or an adequate investigation before you file suit. If he had done his obligated duty in conducting a fair investigation gathering the police report, including the photographs, he would have been able to make that decision much, much sooner than he did. Mr. Abney discussed the expense of gathering photographs as compared to a subpoena, but I don't know if that necessarily gets an attorney off the hook to say that, well, it was more expensive to me to gather the photographs via a public records request than it is by a subpoena. I'm not sure that would get him off the hook.
Isn't that the information, though, that the city normally should have been disclosing automatically to somebody who's involved in an accident?
I don't know the rules and obligations of a police department disclosing information to an accident victim. There is definitely a public record. You could request that. When he received the police report, it noted that there were photographs taken that night. The attorney has an obligation to conduct a fair investigation, and that would include gathering the photographs.
But this is such a bizarre theory. I guess what troubles me here is this is such a bizarre theory that no one is really on notice of something that is a 1 in a million shot. It's almost as though there was a laser in a tree that caused the accident, and nobody thought to look for lasers in trees. Well, you wouldn't normally. If there's a red light, green light case, you don't look for lasers in trees. But if down the road a photograph reveals that there was this bizarre and unusual circumstance, isn't that what the discovery rule is really all about?
It is, Your Honor, but you cannot stick your head in the sand. The discovery rule says when you knew or should have known. So if the attorney had done a proper, adequate pre-suit investigation, which includes gathering all the information, then he could have looked at those 267 photographs earlier in the case, and he would have been able to determine there's something going on, or I believe there's something going on with this light system, and so maybe the city is negligent.
Let's say he had those documents. I mean, are you saying that it was then incumbent upon him to recognize every possible consequence of those photographs, no matter how bizarre?
I would submit to you, Your Honor, that it's incumbent on him to do the investigation, and the investigation would look, I assume, just as he did 5 or 6 months later, to look at those photographs and determine, hey, there's something fishy going on with these 3 photographs.
Well, just to put us on a spectrum, though, because this is not again the kind of thing you would normally look for. Let's say he has all the photographs on day one, and in the lower right-hand corner of one of the photographs, for just a few pixels, there's a guy with a laser aiming it at drivers, trying to cause traffic accidents, and nobody would ever think to investigate for that, but it's noticed in good faith in the tiniest area of one picture a year down the road. Would we say there's no due diligence because that theory didn't emerge until a year later?
I don't know, Your Honor, but I would submit to you that that's just not the case that we have. I know. I'm exploring the sort of spectrum. There are, this is all, like you said, it's a spectrum, it's a bell curve, whatever you have it. There are going to be cases on the very end of the curve where you say, listen, we would not expect any reasonable attorney to have found this eventuality, and so therefore, yes, the discovery rule applies. There are cases that are on the other spectrum that says, yes, most reasonable attorneys would have found this, therefore it doesn't apply.
Well, counsel, let me ask you this. I mean, even your office didn't pick up on the problem with the photos and the malfunctioning lights, right? I mean, your office didn't know that this was a possible issue in the case, that the lights were malfunctioning, and they had the pictures themselves, right?
I would disagree with that a little bit, Your Honor. Our office does not get those photographs until it becomes an issue. We initially got the motion.
I mean, the prosecutor had the file, the prosecutor had these photographs. I'm assuming the prosecutor didn't know that there might have been a problem with the lights and just not disclose that to anybody. I'm guessing that even the prosecutor didn't see that problem in all those photographs. It took the eye of the plaintiff's attorney to see it.
Well, and the only thing I would say is that the issue with the lights was not an issue in the criminal case. The criminal file that the plaintiff received was Mr. Boosfile, who was the original defendant. He was charged with a DUI and driving on a suspended license, I believe, Your Honor. So the light sequence or the timing of lights or what the lights were showing at the time of the accident was not an issue in this case or in his criminal case. So I don't believe the prosecutor would have even been looking at those photographs for that particular issue.
But that being said, the prosecutor didn't bring anything up about this, so it's not something that jumped out to the prosecutor.
I'm not exactly sure what the prosecutor did or what the prosecutor saw. I mean, it wasn't a part of this civil case. Going back to the trial court, again, the trial court's decision in granting the original motion to dismiss, granting the Rule 60C motion, and denying the Rule 60C motion and denying the motion under the saving statute is all of abuse of discretion. Whether or not the trial court had that that discretion to make that decision, I don't think is very debatable in this circumstance. Again, we're talking about the reasonable conduct of the attorney at the time that he made those decisions. I just don't believe that his conduct in this case was very reasonable.
There's a lot of discretion available in this case, but isn't the ruling on the motion to dismiss subject to de novo review?
Again, Your Honor, the initial ruling is subject to abuse of discretion.
You mean essentially the default?
The default ruling, yes, is subject to abuse of discretion.
But then ultimately, at the end of the day, the court looks at everything anyway and makes a determination purportedly on the merits. Wouldn't that be subject to de novo review?
The decision to grant a motion to dismiss, fully briefed or whatever, is subject to a de novo review. Which again, I would go back to the other orders that the court made in this and say that that's an abuse of discretion. Whether or not there's any reasonable evidence or information that she had to make that decision, and I would submit that there was sufficient evidence for her to make the decisions that she made on the Rule 60C motion and the motion for the saving statute. And unless there are any other questions, I'll waive my remaining time and just ask that you affirm the trial court's decision.
All right. Thank you, Mr. Matheson. Mr. Abney?
Yes, Your Honor. I think the proper standard would be de novo. If this is treated as a motion to dismiss or a motion for summary judgment, it's de novo. And the specific question of whether to apply the discovery rule under the Wilmot versus Wilmot case is also de novo. So I think we've got de novo up and down the line on this particular case. As far as the photos, that's just serendipity. I would have never noticed it, and I don't know any lawyer that would have.
You might never have noticed it, but do we really want a rule that says don't bother requesting the basic information in the hands of the police when there's been an accident? Well, it's one thing to say, I didn't notice the guy in the corner with the laser pointer. It's another thing to say, I didn't even ask for the pictures.
Well, I don't think that's part of the standard of care, quite frankly. In my practice, and then I think in the practice of most plaintiffs' lawyers, you don't usually ask for the photos. If there's been a death, you often will. And if there is an extreme dispute about the position of the vehicles before and after the event, you'll do that because you'll get a pretty good clue, especially from skid marks and from where the vehicles came to rest and the damage they did along the way. I don't know if that was particularly an issue in this case. I'm not quite sure why he ordered. I think he was just doing it to see if there was anything interesting that might help in settling the case, so he ordered the pictures. But no, I don't think it's a standard of care or a duty of care for the plaintiff's lawyer to always order the police photos. In fact, we rarely do it. And as I say, I don't know anybody who would be so. In fact, my understanding is what happened is he glanced through the photos after they came in, didn't notice anything unusual, and then went back later and looked at them a little more closely, and all this thing just sort of popped out of them, out of the blue. As I said, I'd have never gotten it. But he did, and at that time he thought, well, I owe it to my client to at least pursue a claim with the city to see if there is some responsibility there for what caused the accident. The police report itself said, quote, "Streetlights and traffic signals were noted to be in good working order throughout the investigation." But apparently they weren't. Yeah. Anyway, I could babble for a while, but I'd rather give my time back to the court unless you have some specific questions for me.
No, thank you, counsel.
Thank you very much.
Council will take this matter under advisement and will issue a written decision in due course. Court's in recess.